What's up?
You seem like you want to come talk to me.
No, I'm just coming to see what car number it is. Huh?
Want to take your hand out your pocket?
Am I detained?
No, you're not being detained. Take your hand out.
I don't have to take my hand out of my pocket. I didn't break no law. Is it a lawful order?
Yes, it's a lawful order.
For what? Officer safety?
I'm telling you right now, take your hand out.
Oh, he's got a gun drawn.
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. You may remember a video that I posted back in September where a couple had an interaction with an Anderson County, South Carolina deputy, and the deputy retaliated against the couple because the man in the vehicle yelled out the window as the couple drove by. Well, today's video takes us back to Anderson County, South Carolina, but this time the focus is on the Anderson Police Department. And apparently stupidity is contagious out there because I can't tell much of a difference between the Anderson County Sheriff's deputies and the officers who are assigned to the Anderson City Police Department as it relates to the way that they respond to First Amendment protected activity. Now, this video comes to us from a self-proclaimed First Amendment auditor with the YouTube channel Dragonfire News. The incident is documented on Dragonfire's channel in 3 separate videos spanning well over an hour in combined length, so I'm not going to play the whole thing. I've made substantial edits for the purposes of our discussion. However, if you want to see all the videos in their entirety, you can see them on Dragonfire's channel. But let's watch how it unfolds, and then we'll come back and talk a little bit about it.
Hello everybody, it's Dragon P with Dragonfire News. Not here at Walmart. You see a cop just wasting taxpayers' dollars. We'll see what his vehicle number is. How you doing, Deb?
Hey,
What's up?
you seem like you want to come talk to me.
No, I'm just coming to see what car number it is.
Am I taking out your pocket?
Huh?
Am I taking your hand out your pocket?
Am I detained?
No, you're not being detained. Take your hand out.
I don't have to take my hand out of my pocket. I didn't break no law. Car number 2036, sitting in the parking lot, not even parked in the proper parking spot, wasting tax dollars money.
Hey, bud, take your hand out your pocket.
I don't have to do nothing you tell me.
Yeah, you do.
No, I don't. Is that a lawful order?
Show me out with a 1080.
Is it a lawful order?
Yes, it's a lawful order.
For what? Officer safety?
I'm telling you right now, take your hand
Oh,
out
he's
your
got a
pocket.
gun drawn.
Sir, take
He's
your
got
hand
his
out your
gun
pocket.
drawn
Take
for
your
a
hand out your
man
pocket.
with a camera coming up to a cop car
Take your hand out
that's
your
sitting in a
pocket.
parking lot. This is considered police brutality because he just drawed. I'll put it right back. I got my keys and lighter in there. Nothing else. I don't have. That's no. You just drew a weapon on a private citizen doing a.
Listen to me.
Huh?
Okay, stop talking at me.
I don't have to stop talking.
Yes, you do.
Goodbye.
Okay, have a nice day.
You too. What's your name and badge number?
My name's Owen. 7.
Owens? All right.
You might not want to walk up to me with your hands in your pocket.
I can walk up to a police officer with my hands in my pocket. That's not unlawful.
Go try and get your little lawsuit and get on my face.
What?
Go on. Go try and get your lawsuit and get on my face. Go.
I got a lawsuit, bud. You just drew a weapon on me for no reason. This is definitely going to your supervisor. An officer, Owens, just drew his weapon on me. Huh?
Right now you're being detained.
For what? For what?
Okay, so it's pretty clear that this officer is completely unhinged and controlled by ego, and it's obvious that this was a retaliation. Now, think whatever you want to think about the auditor. I'm not nearly as concerned about the people who are choosing to take up the mantle of auditing as I am with the officers who are supposed to be upholding an oath that they took voluntarily. Those things have nothing to do with each other. One of the people involved owes a duty to the Constitution, and the other one doesn't. And The auditor will learn along the way what works and what doesn't work, as will the officer. But again, my concern is more about the police than it is about the auditor. So it's hard for me to overlook the sort of immediate violations that I see of the First and Fourth Amendment here. First and foremost, it's a consensual encounter initiated by the auditor. So the officer does not have any legal authority to demand that the auditor remove his hands from his pockets. However, the officer attempting to exercise authority he doesn't have doesn't violate the Fourth Amendment yet. A lot of these cops think that they're being cute by walking a tightrope between a detention and an arrest, but constitutionally speaking, all that really matters is whether the person is seized, at least at this point. Again, the Fourth Amendment protects against unreasonable searches and seizures. Most of the relevant case law says that a person is actually seized when they submit to the officer's show of authority or when the officer applies physical force to initiate the compliance. So here, our auditor is refusing to take his hands out of his pockets, and so we don't really have an actual seizure until Barney draws his gun and escalates this encounter to deadly force for literally no reason. And again, you can make the argument all day long that I want to see your hands because you might have a concealed gun, but it's South Carolina. South Carolina just became the 29th state to allow constitutional carry of both open and concealed firearms with no registration, no permit, no nothing. So again, even if he had a weapon in his pocket, you still have no illegality attached to this attempted seizure of this person. And so it doesn't matter whether he has a weapon. As a police officer, you do not have a right to detain him, stop him, control his movements, or seize him unless you meet the requirements of Terry versus Ohio, which we'll go over more in detail in a little bit. But for now, let's continue.
I'm 10-4. I got one detained.
For what? What are you detaining me
Terry
for?
frisking you because I'm fearing for my safety.
You're going into my pocket. Yeah. This man just unlawfully detained me for no reason. He grabbed me.
Anything else?
Huh?
Can I help you with anything else?
Yeah, I was going to ask you a question while you're sitting in the parking
You're
lot.
walking up trying to pick a fight with law enforcement. That's all.
Oh,
you got one.
Here.
You got one.
I'm walking up trying to pick a fight with
Yes,
law
you
enforcement.
are. What else do you
Goodbye. If I'm not detained, you don't have nothing else to say to me, I'm leaving. The cop gonna get a lawsuit now. Get my tags. It ain't gonna do you no good. Deputy Owens.
If you got nothing else, you need to move on. We got an ordering ordinance.
You don't know what I'm doing here, so you don't have no right to tell me anything. I'm waiting for somebody. You can't tell me to move on. How are you going to trespass me without there being permission? Bullshit. I'm waiting for somebody to get off work at Walmart.
You're sitting over here trying to pick fights.
Oh, you don't know what I'm here for. I've been here waiting for my sister-in-law to get off work, so.
My car with your freaking hands in your pocket.
I can come up to a cop car with my hands in my pocket. That's not unlawful, asshole.
No, that is unlawful.
No, it is not.
Order from a police officer to get your
Bullshit.
And what you do?
Bullshit. That's not a lawful order. Not a lawful order. I wasn't detained. Unless I'm violating the law, you have no authority over me.
First of all, you're freaking loitering.
It is not loitering. I have a purpose now. I'm videotaping you.
All right, cool. Well, your purpose is about to go to jail.
Yeah, well, right. Supervisor.
Okay, you're detained.
Supervisor.
Oh, he's on the way, bro. And guess what? You're going to jail after.
Right. For what?
You got your fight.
For what?
You want a big fight? Right now you're...
For what? I came up to record a police officer, which is my constitutional right to do.
And what else you did? You walked up with your hands in your pocket.
That is not illegal.
Now, what'd you do?
That is not illegal. You jumped out on me.
You didn't listen to a lawful order from a police officer. What'd you do?
That's not a lawful order.
Yes, it is.
No, it's not. No, it is not.
One of the important things to note here is that this encounter will be analyzed both by me and, if it goes to court, by courts in slices, because there are multiple attempts by the officer here to exert different levels of force in separate scenes throughout the encounter. Now, I see the first scene basically lasting from the time that the initial contact was made with the officer until the officer tells the auditor to go try and get his lawsuit and get the F out of his face. So Officer Owens is essentially giving him an order to disperse, which we'll look at again in a little bit. But because this officer's ego is fragile and his brain is apparently not working, he decides to retaliate a second time against Dragonfire as Dragonfire is following the officer's order to disperse. Keep in mind that he's following the order. He's going to his car. He's leaving. He's just telling the officer in the process that he's actually going to complain on him and that he's going to be talking with the supervisor. And with nothing else going on, no new information, and only the auditor saying he's going to complain on the officer, Owens decides to apply physical force and undertake a second seizure. This rises to the level of a separate seizure because he's already been seized with the gun draw and then he's been released. So that scene is over. We're now moving on to the scene where he is seized on his way back to the car while following the police officer's orders. This time, the officer just grabs him. He does what he calls a Terry frisk, but it's not a Terry frisk because we can hear Dragonfire say, well, you're going into my pockets, which of course isn't appropriate for just a Terry frisk. You have to stay on the outer layer of the clothing. You can't go into the pockets unless you feel something that you can articulate is shaped or feels like a weapon, and then you can go into the pocket for officer safety, but we don't have that here. Now, at this point, I'd like to invite you to check out my 2 breakdown videos on the Terry versus Ohio case so you'll have a good understanding of how it all works, and I'll leave an end card at the end of the video for you to be able to do that. But the Cliff's Notes version is this. Terry is essentially divided into 2 parts as it relates to law enforcement action. First, if an officer has reasonable articulable suspicion that criminal activity is afoot, the officer may perform a Terry stop, otherwise known as an investigatory detention. Now, how we get there constitutionally is that the officer has to have some information, more than a mere hunch, and then based on that information that they have at the time of the seizure, they have to be able to articulate that the person is either committing a crime presently, is about to commit a crime, or has already committed a crime. Now, we have none of that here. And the officer is actually silly enough to say the quiet part out loud because he can't control either his emotions or his mouth. But let's leave that aside for the time being. Assume for a second that he actually has reasonable articulable suspicion. The Terry detention, the investigatory detention known as a Terry stop, does not automatically trigger the right or privilege by an officer to do a pat down, which is otherwise known as a Terry frisk. That is the second part of Terry versus Ohio. In order to justify Terry frisk, well, one, you have to have a valid reason for the stop, which we're assuming we have for the purposes of this exercise, but we don't actually have. But 2, you have to have information that would lead a person of reasonable caution to believe that the subject being detained is both armed and presently dangerous. Now, here's why we don't have that here. Maybe, and it's a stretch of a maybe, in the first encounter, the guy holding his hand in his pocket could have been used. Again, we're assuming something that we know is not actually true. We're assuming that he had a right to detain him in the first place. If we don't have a right to detain him, we never even get to this analysis. But if he had a right to detain him and the guy wouldn't pull his hands out of his pockets, then the officer might be able to use that and say, well, officer safety, blah, 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 blah. I needed to pat him down for officer safety. And his conduct of refusing to pull his hand out of his pocket led me to believe that he may be armed and dangerous. But the officer, again, enforcing his feelings instead of the law, just pointed his gun at the guy and then let him go without a pat down. So his privilege to do a pat down would have been most persuasive during the first encounter, but we're not there anymore. He can't allow him to leave having no new information upon which to base a new detention and then stop him and frisk him during the second scene, which he obviously does. He already told him to leave. Dragonfire explained to the guy that all he had was his keys and a lighter in his pocket, and then he was following the officer's orders and going back to his car. Even if the officer could frisk him lawfully, he can't go into the pockets again unless he feels something he can articulate as a weapon, but we don't have that here. And to make matters worse, he makes voluntary statements after the pat-down indicating that he knew the officer wanted a fight with law enforcement and he gave him one. Well, Officer Owens, if you ever see this, aside from showing how small and fragile and insecure you are, all you did with these statements is admit that you're actually guilty of First Amendment retaliation. Owens admitted in the first seizure that he believes the guy was fishing for a lawsuit by recording the police and initiating an encounter. Now, Dragonfire, for his part, did make some mistakes in this encounter. First, when the officer released him and asked if there was anything else he could help with, Dragonfire says yes, and he voluntarily re-engaged and said he was going to ask him a question. That now becomes a new consensual encounter. Now, that part didn't last long, but he still voluntarily engaged. And what he should have done is he should have began to walk away and say, look, I'd like to be free to go and on my way. But as he goes to walk away, Officer Owens initiated a second seizure, which to me is the beginning of the second encounter with a separate analysis. Now, one of many places where the cop screwed this up is in his arguing back and forth with Dragonfire during the second seizure, because again, during the voluntary part, where the auditor was asking him questions, the officer said he believed that the guy wanted to start a fight with law enforcement, which, of course, completely dispels the lie the officer told underpinning the reason for the stop and frisk that was getting ready to happen. He never thought this guy was committing a crime. He never thought the guy was armed. What he believed was that Dragonfire was an instigator and a law enforcement agitator, and you know what? He'd be right about that, and both of those things are, you guessed it, protected under the First Amendment. And like a moron, he played right into his hands multiple times. And believe it or not, it's going to get worse. So let's see what happens next.
So what's going on, man? I'm just now pulling up. I have no idea what's going on.
I just got out to go and see what card number it was. I'm a First Amendment auditor, journalist. I go and film cops in the course of their duties. That's my right. He's been sitting here since I pulled up. And parked and not even parked correctly in the parking lot, right? So I went to get his car number and go around his car, get the plate number. He jumps out and's like, get your hand out of your pocket. I don't have to take my hand out of my pocket unless that's not a lawful order. There is no law against me walking around with my hand in my pocket.
I'm not battling you at all.
I'm not saying you are, but I don't have to take my hand out of my pocket.
Listen to what I'm saying. What part of what he said was unlawful?
There is no law that says I can't have my hand in my pocket.
What part of what he said was unlawful?
Nothing.
Okay.
But there's no law that says I can't have my hand in my pocket. So it's an unlawful order.
Look. You keep saying the same thing over and over. Okay, look.
Well, I'm done talking.
What did he say? He gave you an order, correct?
No, he told me to get my hand out of my pocket. That's not a lawful order. There is no law that says I can have my hand in my pocket, you idiot. No, it's not. You have to have a law to back it up, you idiot.
You might as well shut that car off because you can't go anywhere. You're detained. I'm telling you right now. If you pull off right now, you will.
I want your supervisor.
He's on his way. But if you pull
He pulled a gun on me.
Yep, I did because you had your hand.
He pulled a gun on me for having my hand in the pocket. That is not a lawful order. That's illegal. That's police brutality. There is no reason for him to draw a weapon. He's got an unlawful.
You don't even know what you're talking about.
You got a taser. You could have pulled your taser instead of your gun, you idiot. He pulled his gun on me.
So for right now, for purposes of what's going on right now, you just detained to our supervisor.
What crime am I breaking?
Right now, you're loitering.
No, I'm not. I told him I'm waiting for my sister-in-law to get off work from Walmart. That's not loitering. My sister-in-law works here, and I'm waiting for her to get off work. When I pulled up, he was sitting there and been sitting there since I pulled up here.
Okay, so now this police officer has decided to detain the auditor for a third time. But this is where it gets really bad because, and this is not going to surprise you much, but a supervisor is requested and she's going to make it even worse. But the thing to note in this encounter is that Owens here, with his vast understanding of constitutional parameters, has allowed this guy to get back into his car. Keep in mind that if this was a traffic stop, he'd surely be ordered out of the car for officer safety because of Pennsylvania versus Mims, which is the only case that they can cite, even though they don't really understand it. And the argument in that particular instance would be that the officer has no way of knowing what kind of weapons he had access to in the vehicle. Well, you patted him down unlawfully, and then you gave him access to a huge SUV. You detained him inside his SUV without even attempting to remove him from the vehicle. And this goes on, guys, for like 45 minutes. And with all that access to weapons, yep, officer safety and all. And oh, by the way, you still don't have a lawful reason to detain him, whether on foot or in his vehicle anyway. Now, Owens does get creative and says that he believes that the guy's being detained for loitering, which of course is complete bullshit. I'm not even going to go through a detailed analysis of the loitering statute because they don't even apply to this situation. But I'll just say that many, many loitering statutes and ordinances have been declared unconstitutional. And the reason is because of this right here. It gives the police entirely too much discretion to determine what is and what isn't loitering, and it doesn't put the person on notice as to what conduct is unlawful. Loitering is basically under the law an assumption that a person is trespassing. So normally, like a trespassing ordinance would require that a person be given notice that they're not welcome on the premises and then they could leave. But loitering is kind of saying, well, it doesn't look like you're doing anything that's legitimate here, so you're loitering, which is essentially like, well, it's obvious that you're going to trespass because you're not here for a legitimate purpose. But the specific loitering statute that might apply to Walmart here is under Section J of the Anderson City Ordinance. And it basically just says it's prohibited for a person who congregates or remains within the boundaries of a commercial property either after business hours or during business hours without contemporaneous commercial activity. Of course, if you don't know, contemporaneous means at the same time. So I'm there, and at the same time I'm there, I have commercial activity connected with this business. But then there's a conjunctive portion of this which requires that the premises be posted with conspicuous no loitering signs. And we don't know whether we have signs here, and he's also told the officer that he's waiting to pick his sister-in-law up who works at Walmart. But most importantly, the remedy for loitering is not detention or arrest, other than to get his ID. It's to tell the person to disperse or leave, which again, he told him first and he was trying to leave. He was just talking smack as he was walking away. The only conduct here that could actually be considered for the purposes of establishing loitering would have been his initial approach and sort of critical questioning of the police officer, which, as you'll remember, was never considered loitering by the officer. But almost immediately when this guy gets in the car, the officer tells him to leave. He never asked for his information. And then directly after the guy starts to get in the car and leave, the officer then tells him that he can't leave because he's detained again. So you have to pick one or the other. You can't be loitering or trespassing if the cops won't let you leave. This is just a constitutionally butchered encounter from the beginning. But don't worry, the supervisor's on her way, and we're going to get an opportunity to watch the leadership that Owens has on shift to see if we can figure out why he doesn't have a very good understanding of how things work. And then we'll come back and wrap it up.
Yes, ma'am.
I'm the supervisor.
How you doing?
I'm good. How are you?
Well, I got a complaint. This deputy first said that I didn't follow lawful command by removing my hand from my coat. And then he drew his wet gun on me.
Okay. Did you not remove your hands from your pocket?
I don't have to remove my hand from my pocket. It's not a lawful order. I just looked it up.
It is a lawful
No,
order.
it is not.
I think it's an officer safety issue.
The officer safety? What about public safety? He could have drew his taser instead of his firearm.
No, because he doesn't know if you have a gun or not.
It doesn't matter, ma'am. I do not have to listen.
If you had a gun, if you had a
Ma'am, I looked it up. It says you have the right to ask. It does not say you have the right to demand. Ask me if I remove my hand from my pocket. Doesn't say I have to. If there is no what law says I have to remove my hand.
officer safety issue.
There is no law that says that you have to ask remove your pocket if you ask by a police officer.
He didn't ask you before he told you to?
Huh?
Are you upset that he didn't ask you before he told you to?
No, it don't matter if he asked or told me to. I don't have to. No, I don't. No, I don't. It's been fought in court and won. I know it has because I've seen case law after case law after case law on YouTube. What I did was I got up and I went and recorded his car, and I had my hand in my pocket. I had my camera in my other hand. Who in their right mind is going to walk up and have a camera in their hand showing, filming themselves shooting a cop? That wouldn't be very smart. But I know for a fact because I fought it in court before.
Well, if you had a weapon on you, he doesn't know if you have.
I don't. He patted me down.
He realizes, but that was after the fact.
It doesn't matter. Now he's got me illegally detained.
That's not illegally.
What am I here? What's he detained me for?
Loitering.
I'm not loitering. I'm waiting for my sister-in-law to get off work. She works here at Walmart.
Okay.
That's not loitering.
And you want to take your hands out of your pocket, right? And you want to identify yourself?
I didn't. He didn't ask me to identify myself. Ha! It's all recording. It's all unrecorded.
Okay. Let me ask.
No, you did not. No, you did not. And unless I am suspected of a crime, I don't have to identify.
That's valid.
Huh?
You're right.
So I'm not suspected of a crime. Taking my hand out of my pocket is not a crime.
Not a crime.
Then he unlawfully drew his weapon on me. If it's not a crime to not take my hand out of my pocket, then there's no crime for it.
It's a safety issue.
Safety what? Whose safety? His or mine?
You got a gun in your pocket. How does he know? He doesn't know if you got a gun, if you got a knife, if you got a taser, whatever you're doing, you know?
Mm-hmm.
Okay. So I'm just gonna re-explain something, okay? So at this point, you are free to go. You're being detained because we were trying to figure out what was going on, okay?
Unlawful
When
detainment.
you approach a car,
I don't have to.
I gotta review video footage. Just listen to me for a second.
I'll take it up with your supervisor in the morning.
Can I just explain something?
No, I'm done. If I'm free to go, I'm free to go.
Free to go.
I got video evidence.
Well, there you have it. I don't have to say very much about this supervisor for you all to figure out that she's also an idiot, and possibly her leadership is the reason that Owens doesn't understand how anything is supposed to work. And they both seem to have the same misunderstanding of how important their subjective personal feelings are as it relates to lawful or illegal activity. And the longer they actually hold him here, the closer this detention becomes to an arrest under current case law and precedent. But even though it's very clear to me, and it should be very clear to you, that this case is wrought with multiple violations of the constitutional protections for this auditor, I predict that in spite of that, this case would not yield very much from a lawsuit. I'll explain that shortly. But in closing, we are 2 for 2 now for our focus on Anderson County, South Carolina, and that area of the country allowing their officers to retaliate against First Amendment protected speech. You have to remember that even if a person is a police agitator, being critical of the police is protected under the First Amendment. Recording police in the course of their duties is also protected under the First Amendment. And the reason I said this case won't yield any serious money is because if it goes to trial, the jury will fix the award. And the jury, in my opinion, won't like this auditor very much. Now, I don't mean to be too hard on him because he is trying, but he's not any better educated on how to deconstruct what the police can and can't do and check them in the moment. He's not a real articulate guy, and he's not all that different from the cops in that he's getting emotional and allowing that emotion to keep him from being able to try and control the conversation. He's not using the power of questions to sort of elicit incriminating responses, and in my opinion, the jury will see this as sort of a 2 wrongs don't make a right type scenario. At trial, my prediction would be that he'd be awarded nominal damages of maybe $1 and then reasonable attorney's fees, if even the reasonable attorney's fees. In fact, I'd be surprised if a civil rights lawyer would even take his case to trial. He may be able to find someone to represent him for the purposes of negotiating a pretrial settlement, but most attorneys are going to look at the situation and understand that this case will not bring about a big verdict. He has no physical injury. He's not a very sympathetic plaintiff when you consider that he'd have a deep red state jury that loves its cops. I don't see many dollar signs attached to this one, which is a shame because my opinion is that the violation alone should trigger a strict liability award of some amount. You know how debt collectors, when they call people, they're subject to strict guidelines? There's actually a federal law called the Fair Debt Collection and Practices Act, and the federal law provides a strict liability award of something like $1,000 for every infraction. That's why when they call, they'll say, well, this is an attempt to collect a debt. When they send a paper out or a letter out, it'll say on the paper, this is an attempt to collect a debt. That's because those are parameters set out by the FDCPA. So every time a debt collector does something that violates the provisions of the FDCPA, there's like a separate award of $1,000 for each of those things. So if they call you 3 times, that's $3,000. If they send you 2 letters and that's wrong, that's $2,000. So you already start out with like a guaranteed award. Strict liability just means that it doesn't matter what your reasons were. You either did it or you didn't. That's what, like, speeding is a strict liability offense. It doesn't matter whether you intended to speed or not. You either sped or you didn't speed. And a system similar to the FDCPA violation award is what I believe we should have for constitutional violations. Because in this case, I believe I could actually make the argument for both a First and Fourth Amendment claim in each of the 3 separate seizures if there was a strict liability award of, say, $5,000 of each of those things. Well, we'd start at $30,000 in awards plus reasonable attorney's fees for having to take it to trial and collect it. And then it might be something that could act as a deterrent. But until something like that is in place, auditors who, again, not trying to be too hard on this guy, but lack the awareness to understand that it's the people in their community who will decide the value of their case, and then they find themselves engaged in these battles with law enforcement, those people are going to have a hard time finding lawyers to take their cases because they're not going to get very much money. The lawyer has to type hours and hours and hours, possibly pay people in order to get them deposed and all kinds of stuff. So my suggestion to Dragonfire, without coming down too hard on him, would be to simply record. Don't go up and start mouthing off to the cops without knowing how you're going to respond to that situation. Figure out a simple script. Script out some simple questions to ask, like, what am I being detained for? What is your reasonable articulable suspicion that I've committed a crime? Not arguing, well, I didn't do this, I didn't do that, and both of you yelling at each other. If you're not great at making cogent arguments when the tensions are high, you shouldn't expect to be clear-headed and able to win a debate with a cop in the middle of a confrontation that you initiated without even knowing what you were going to do next. Regardless of the fact that you may see YouTube videos that show you auditors that may look like they're antagonizing police officers without a plan, most of these guys who are good at this have a plan. They have a fallback position. They're going to lead the officer into a trap. In my estimation, what Dragonfire did here was lead both of them into a trap. Because by getting in the mud with the police officer and not being the reasonable one in the encounter, he dragged them both in the mud, and I think that his potential suit will suffer as a result. Anyway, that's all for this one, guys. If you do want to support the Southern Draw Law channel, I'll leave the PayPal and Venmo links here on the screen and in the description, as I don't use any sort of membership model. I'll leave an end card to my 2 videos covering Terry versus Ohio in depth if you want to check those out. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel. Leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.